Magazine and a Rising Star by Texas Lawyer. She was also named Attorney of the Year by the Fort Worth Paralegal Association. So she's super cool to be doing this with us today. Let me see, and stop sharing. Okay, so if you want to go ahead and take over, Judge Allen.
All right, thank you.
I just need a quick minute. I'm so sorry. We are recording this session just for everybody to know. If you will hold your questions till the end, or you can type them in the chat room, we would be glad to entertain those. And the reason we're asking you to hold them till the end is because we will turn the recording off so everyone is comfortable asking their questions and knowing nobody else would be attending their business. So anyway, sorry, Alex, you didn't mention that and I wanted to jump in.
Oh yeah, my bad. No worries. And yeah, I'm going to be helping watch the chat, so if
we can answer if we can.
Yeah.
Okay, Brooke, we'll turn it over to you.
All right, thank you, Alex, and thank you, Cindy. Thank you all for being here. One thing about Zoom is more people are actually able to attend these, so I appreciate you all being here. Today, I also have with me Elizabeth Hart. She is one of our assistant court investigators. She has her master's in social work, and so you're going to hear about her and how her and her colleagues really help this court and how they are willing to help you guys whenever you have a question and that type of thing. You'll hear about them or her and her colleagues in just a little bit. Okay, I am going to try and share my screen with the PowerPoint and see how this goes. All right, I came up with this when I first took the bench. We were having guardianship trials that were scheduled about 10 or 15 minutes apart. You came in, there was about 10 questions asked, and your loved one's rights were taken away. Their right to vote, their right to marry, their right to drive, their right to decide where they want to live, really within 15 minutes. And I have a litigation background. If you didn't notice from the introduction, I used to try cases, and when you try cases, you really dig into the statute. You think about what is the burden of proof under the law. And so when I started looking at this guardianship, I was like, no, we're not doing this anymore. We're not doing 10-minute hearings. These are trials. And guardianship definitely has its place, but we need to make sure that the burdens are met under the law. And so my hope today is to just give you guys the tools to look at what the law says, look at your life and what's going on in your life and your loved ones, and determine, do we need to rush to the courthouse or is this a last resort? And I know it's hard because we're on Zoom, but a couple questions I want you to think about if you've ever been asked. Most of the time, well, every time I've given a presentation, I say, raise your hand if you have been told that as soon as your child turns 18, you have to get guardianship or the state will take them away. There is at least one hand that goes up. Oh, Zoom. Okay, see, I do Zoom every day for hearings and I see a little hand. I don't even know how to do that. Okay, at least one person, right? Usually multiple hands. How many have told you that if you don't have guardianship, this is my favorite, if you don't have guardianship and your loved one's in a car wreck, they'll amputate their leg without telling you? Okay, that was my favorite. Oh, okay, we're getting more hands on that one. Or if, let's see, you don't have guardianship, your child's going to do drugs and become a prostitute. Okay, these are all things that people are told. You guys have been told this, and you've been told this by people you've trusted, attorneys, doctors, teachers. So I want you to know that you're not alone. And I want you to know that there's someone here that is in a position. I'm an elected official. I am a judge that hears these cases, and I will tell you, the state will not come and take your loved one. All right? Honestly, the state doesn't have the facilities or the funds or the people to do that. But that is just flat untrue. Now, we have CPS and APS for a reason. All right, that's if people are being neglected or they're being abused. CPS and APS will come and take your loved one, yes. But if you are taking care of your loved one and they turn 18 and they have an intellectual disability, no one is going to come take them, certainly not the state. Now, the second thing, one of my social workers, when I started, she really had been told they were going to cut the leg off if you don't have a guardianship. Well, let me tell you, if any of us get into a car wreck and our leg has to be cut off to get us out of a burning car and save our lives, they absolutely are going to cut off your leg and get you out of that burning car. They are not going to stop to see if you are under guardianship. It just doesn't factor into those things. So these things, like I said, are told to you by people you trust. And so we're going to go through the law and we're going to dispel, hopefully, some of these myths. And then if you guys have any other questions at the end, as Cindy mentioned, I'll be taking those. All right, so a little bit about probate court 2. Now, we are still doing 2019 statistics. I can tell you our 2020 statistics are completely messed up because of COVID. And our courts are more closed right now than most businesses, but I'm going to try not to get into that. All right, so our filings were up in 2019 for decedents' estates, for guardianships, and we hear the civil mental health docket. I am very well funded by, thank you, the taxpayers of Tarrant County. So I do have 12 team members to help us out. If you look at these team members, what you're going to see, okay, if you're not on mute, I'm going to ask you to put yourself on mute. If you're not on mute, if you'll put yourself on mute, just because I'm hearing you and I'm not sure if others are hearing me. But if you look at the 12 team members, you're going to see a court investigator for guardianship, a guardianship auditor who does more of our guardianship estates when we're dealing with money, dealing with guardianship. And I have 3 assistant court investigators. And we have a guardianship specialist who really helps us get everything where it needs to go. It needs to go to the attorneys first. It needs to go to me. It needs to go to our court investigators. And then we also have court visitors, which are interns. So although we have the smallest number of filings, we have the most team members that are focused on guardianship. And that's because we have approximately 1,300 guardianships in our court. So here's how the filings went in 2019, an information letter. So if you have a loved one that you think needs a guardianship, you can file an information letter, and we by law are required to look at that. So we're going to, one of our attorneys is going to assign it to an assistant court investigator that are social workers. Y'all, I can tell you, my predecessor had the idea to have social workers on staff, and it was brilliant. You're going to hear from Elizabeth. She can get to the bottom of things and help people so much quicker than an attorney, because a lot of times in these suggestions of needs or information letters, it's not legal advice necessarily that people need, it's how to fix a problem. And so she especially is very good at looking at what is the actual issue here and how can we fix it and can we avoid a guardianship. So that's how I would say the majority come into us. You can also have a private application that an attorney can file for you. And then we have a guardian of the person, which is GOP, or a GOE is guardian of the estate. So sometimes we'll have that combined and sometimes one or the other. Jail temporaries, every once in a while there'll be somebody in jail that may need a guardianship, although those are extremely rare. And then we'll get transfers received from other counties. And emergency protective orders are, if someone is in imminent danger, Adult Protective Services can bring an emergency protective order. And by law, there's a statute that says if I have probable cause to believe someone needs a guardianship, then I have a duty to investigate that. So we're going to have a social worker investigate that. And if they come in and say, yes, a guardianship is needed, then it'll kind of be like an information letter, and we'll go through that process. And we'll talk more about that in a little bit as well. So in 2019, we did about 190 investigations. 2020 was, like I said, we're just not even going to count those statistics because it'll just be an anomaly and it'll throw all our numbers off. All right, so I said we have about 1,300 guardianships. We're actually down, I think we're up to probably around 1,250 now, but in 2019 we were back down to 1,171. And that's why we have so many people on staff to deal with guardianships. A lot of people think, okay, I'm going to go into court and this is like getting custody of a child. So that's another myth you might have heard. Oh, just go get guardianship. It's like getting custody and you're good to go. Well, that's not true. Once you get, well, let me tell you exactly what guardianship is and what it's not. So when you go get custody of a child, in Tarrant County, you would go to the family courts and, well, you should go to the family courts instead of coming to get guardianship if they're under 18. And they would do maybe a home visit. They would make sure that you were, would take care of the person. And if you're going to do an adoption, it would be a little bit more than if, somebody had died and you took your grandbaby in or something like that. If you're doing adoption, they'll do a little bit more on that home visits and things. And then at the end, you have an order saying you are the legal parent of Amy. You go about your business. Amy turns 7, 8, 9, 10 till she turns 18. Unless you go back to the court, you never hear from the court. That is not the same as guardianship. In fact, those people who have been told if you don't do a guardianship when your child turns 18, that the state will come and get them, that's exactly what guardianship is. You're actually asking the government to come into your life, to make your child a ward of the state of Texas. And the state, by statute, has given me the authority in Tarrant County and Judge Ponder, for if you land in Court 1, and delegated us to make sure that wards are taken care of if they become a ward of the state of Texas. And in turn, if I put someone under guardianship and make them a ward, then I can appoint someone I believe is suitable to serve as their guardian. Then I'm going to follow up. I'm required by Texas law, and I can tell you I follow the law. So there are going to be some things we're going to talk about each. I guess my attorney says, when you invite the government in, the government is coming, but the government doesn't leave until the government's good and ready. And when you put somebody under guardianship, the government is with them until they pass away, and sometimes even after that to close things, or they're no longer under guardianship, either because it's closed or because they've regained capacity and there's a restoration. So in our court, we see about 1% of minors. Like I said, every once in a while, somebody will come in instead of going to the family court where you can just get your order and go, they'll come into our court. Now, if people do that, well, we always send an assistant court investigator to talk to everyone who files a guardianship. So if you do that and it's for a minor, they're going to explain the difference. If you go to family court, you get your orders, you have custody, you're all good. If you come to guardian, if you do a guardianship, you're going to be answering to the court every year. Most people will say, oh, we're going to go over to that other court. All right. And then we've got about 43% are younger adults, 56% are adults over 35. Now that is starting to change, and that's not an anomaly with 2020. We are getting more younger adults under guardianship and fewer adults over 35. Now that could be because we'll talk about at the end, powers of attorney and people getting their estates and their persons in order before things happen as we age. We have temporary guardianship. So if there's an immediate need, you come in, we must have that hearing within 10 days. And then within guardianships, we can hear anything that a district court or a county court can hear. So we can hear divorces, and we do have wards that get married and then they get divorced. We have quasi-possession orders. So if if there's parents and they're divorced and they can't get along, then they can ask for possession orders. And civil litigation, for instance, medical malpractice or personal injury. We can actually hear all of those lawsuits as we call an ancillary to a guardianship. And then I mentioned earlier the emergency protective orders that Adult Protective Services brings. All right, so we talked about guardianship and really what it is and what it isn't. Here is your Texas Guardianship Association as to the definition. Court supervised, again, the state of Texas has delegated to me in Tarrant County and Judge Ponder, a court supervised administration for a minor or incapacitated person. The person called the guardian is appointed by the court, and again, that appointment can be taken away to care for the person and or the property of the minor or incapacitated person who is called the ward. All right, so being under guardianship, most of the time the ward is going to lose all rights. Now, I will say if you come into my court and you don't prove that every right should be taken away, I don't take that right away, because you either meet your burden under the Texas law or you don't. So you might meet your burden to take away the ward's right to marry and for residence, but you may forget to say anything about driving and voting. Okay, I'm not going to take away driving and voting because the person bringing the application did not meet their burden under the law. And also, just so y'all know, parents, driving really isn't up to me. The only thing that the courts can do, the state of Texas does through a guardianship proceeding, is take away your right to take the driving test, which I'm told if you send a letter to the Texas Department of Transportation, you can actually do the same thing. So if you're just worried about somebody that's going to go and drive, there's alternatives to stopping that. And the guardian is in charge of all decisions, although we do have the ward's Bill of Rights. So that's a little bit of a balance. Now, as a guardian, the law requires you to read the ward the Bill of Rights every year. That is the law. If you don't do that, I will not approve your letters for guardianship because I'm going to enforce the law. So I mentioned earlier that in family court for custody, if they're under 18, you get to just go in and you get your letters and you go. That's not the same in guardianship. So every year, my court is going to send out a court visitor, and those are interns. So we get interns either that are getting their undergraduate in social work or their master's in social work from TCU, Tarleton, or UTA. And they are all trained by one of our assistant court investigators. They all have a background check, and they're going to come into your home and they're going to talk to you as the guardian. They're going to want to see the ward's room. They're going to talk to the ward, and they're just going to make sure that everything is going well. That report is then reviewed with Darrell Walker, who runs that program right now, one of our assistant court investigators. He's going to talk with the court visitor, see if there's any follow-up. Once he's good with that, that's going to get passed on, and my associate judge is going to look at all of those reports, and that's Judge Lynn Kelly. And if she sees something on those reports, she's going to follow up with Mr. Walker and say, you know, I saw something on a report. It kind of caused me some concern. Let's follow up. And so she's going to be doing that. Okay, my daughter's home now. This is she just gave me a hug if you saw her pop in. Then you're also going to have to file what's called a guardian of the person report, and that's going to be filed with me. Well, with our court, and that's going to go to me. Our paralegal is first going to screen it to make sure you've answered all the questions, to make sure that you've said you read the Bill of Rights, to make sure you've listed their doctors, all of those things are answered. Then it's going to come to me. I personally review every single one of those. So that's about 1,100 to 1,300 a year. Every year I'm going to review those. I too am going to follow up. And what's interesting, Judge Kelly and I have, we look at things very differently, but I think it complements each other. So for instance, she looked at an annual court visitor report and she saw, okay, the ward is going to work at Whataburger every day. And the ward is riding their bike at, let's say, 4 o'clock in the afternoon. And the ward is riding their bicycle home at 9 o'clock in the evening. So she followed up and said, let's make sure that this ward has items in place so that we know this ward is safe riding their bicycle home at night. I looked at the guardian of the person report and I said, wow, this person's holding a job. They know how to get there, how to get back. They're on their bicycle. They're maneuvering all this stuff. Why is this person under a full guardianship? Is there an opportunity here where we can give some rights back or possibly restore this person? Can this person vote? They're working, they're making a lot of decisions. I mean, y'all, people voted for me because they liked my name or they thought I was pretty. All right? So when people tell me, oh, they can't make a decision to vote, or oh, they'd have to ask their parents who to vote for. Well, don't we all discuss who we're going to vote for with people? Maybe not everybody, because, sometimes you don't want to discuss it with the person who doesn't agree with you, right? But we discuss those things. And then people will tell me, well, they're never going to vote. Well, how many of you don't vote? But how many of you want your right to vote taken away just because you don't vote? Those are two different things. So she looked at it. She was making sure that this was safe. I also, of course, was concerned about safety, but I looked at it and said, hey, maybe there's some alternatives here, maybe supports and services, and we complement each other and those types of things. But those are two follow-ups that we would make. And Mr. Walker is then going to be calling the guardian and discussing this. Hey, what do you have in place? If you don't have anything in place, the court's going to require that. We want our wards to be safe. And then, hey, have you ever thought about a supported decision-making agreement? Have you ever thought about, does the ward, want to vote? Does the ward, want to potentially learn how to drive? Those are just different things, because one of the things the law requires in Texas is for us to make sure that our wards are doing as much as they can. And so those are two things. Also, if there is money involved, then you're going to have to file an annual accounting. And we are going to have that audited. Our auditor is an attorney, a CPA, and a certified fraud expert. I have no idea what she wanted to work for me or in this court, but I love it that she does, and she picks up on little intricacies that we are going to follow up on. And then, of course, if you're a guardian of the estate, you must always be represented by counsel. The ward's estate can pay your counsel, but it has to be approved by the court too. And if if there's a lot of things that the council's doing because you're not doing your accountings properly, you may be on the hook for some of those fees. And of course, at the bottom it says we review the reports. As I've explained, we can remove people without notice. So for instance, APS, if they investigate a case and it's a ward involved, they are going to send us a report that there's an investigation. And then we're going to get one of our social workers on that as well. We're not just going to rely completely on APS. I know, especially in 2020, APS and CPS are even more overworked than usual. So we'll get one of our assistant court investigators. And let me tell you, if I find out there's something going on, I will remove you without notice. And we can have a hearing later and you can get your side of the story, but I'm going to make sure that our ward is safe and in a safe spot. And that's going to be our priority. All right. So we've talked a lot about this. Every statutory probate court is required by law to establish a court visitor program. Those are our assistant court investigators. They all have their master's in social work. They're excellent at what they do. And then we have our college level and master level interns. And they're the ones who do the visits. That's not to say that you're not going to have assistant court investigator come out after you're under guardianship, but that is probably if we're looking at restoring, if we're looking at giving some rights back, or if we're concerned about something going on. And let me just take a step back right now with what's going on with COVID. You guys, we are and have been for almost a year now. We are ripe for abuse for our loved ones, whether they are in a group home or if they are in a nursing home or an assisted living. I encourage you to go visit them. Lay eyes on them. If it is through a window, if it is through a door, if you can get in, get in. The caregivers are overworked. There's not as many eyes on our loved ones, and so we've got to be extra vigilant. And I say this, my grandmother was in memory care, and I was visiting her through a window and through a door, and just making sure that she was mentally doing okay. Now, you know, she had some dementia, but she at least understood why we weren't there all the time, which was a blessing, because I know many of your loved ones don't necessarily understand why you used to be there every week, or, you know, go to dinner every Wednesday and you're not there. But I'm just going to encourage you, be extra diligent, go make those visits. I know they're hard, but we've got to make sure that our loved ones are being taken care of. And I absolutely hate the lockdown. My grandmother was safe in her memory care, and she got COVID and she passed away. Passed away from pneumonia, but you know, the COVID caused pneumonia and all that stuff. So just be with them and give that extra love to all of our caregivers as well, and mental health. That is just so important right now. That's kind of off the topic of Guardian, but just your loved one with a disability, with dementia, with all of those things, just give them that extra love and make that extra effort, because I know it's hard on everybody, them and the caregivers. All right. We kind of already went through what our interns do. They're going to report their findings, and we're going to follow up on those and see if anything needs to change. If it doesn't, then we'll approve the guardianship letters be issued for the next year. All right, those are the annual reports we talked about. And if you don't follow a report, you can be removed, you can be held in contempt of court, you can be fined, all sorts of different things because you're failing to follow the law and you're failing to follow court orders. Now, we do give you reminders. We give lots of reminders. So by the time we're looking at contempt and those things, we've given you phone calls, emails, probably a letter, and then we've asked you to come to court because you still haven't done it. So we do try and accommodate everybody. All right, that's the annual determination of whether it should be continued or modified or terminated. And again, that by law, we have to look at those things. So when I see the person that's working and making all these decisions, by law, I'm required to see, hey, let's have somebody follow up and see if we need to restore some rights here. Okay, so how do you get, this is a path to a guardianship. I talked earlier about we have the private application, that's you hire an attorney and they bring their application. APS, Emergency Protective Order, those are very rare. I think it said, 5 to 7 a year. And then the information letter we talked about that you can just send in and file with the court. We are always going to appoint a social worker on all 3 of these. On the APS Emergency Protective Order and the information letter, we're going to appoint our court attorney. All right, so our court attorney is going to look at it in conjunction with the social workers. There's an investigation, no matter what. All 3 types get an investigation. And then there's court investigator consideration if there's not a private, okay? If you get to the investigation and you're a private application, you can set it for hearing. The court investigator, if you went through an information letter or was brought in by APS, he's going to look at that as an attorney, and he has a burden to prove. I can tell you all, his burden is the exact same burden as the private attorney. Now, I will tell you one difference is that he is a former trial attorney. So he could tell one time when I asked a question that he had not met his burden in my mind. Being a trial attorney, he identified that and he continued to call witnesses and ask questions until he met his burden and granted the guardianship. But he has the exact same burden under the law as a private attorney. So if the court investigator does not feel he can meet his burden or that a guardianship is not needed, he is going to ask me to close the case. And I'm going to go on his recommendation that there is not a guardianship needed because there's supports and services or alternatives, or sometimes it's because they don't even live in our jurisdiction, so we don't have jurisdiction. Or if he believes there does need to be a guardianship, then he's going to set that for hearing or trial. The private application always gets set for trial if your private attorney does that. If you have an APS or information letter and the court investigator does not, the court investigator closes the case, you can always hire a private attorney and bring the case, and you will get your day in court, your trial. You can file another information letter if you have Well, you can file another information letter, but if you keep filing information letters with the same facts, you're probably going to see yourself in front of me for contempt, just because our resources are not great, and so we can't have our social workers going out so many times. But if facts change, then of course include those facts that have changed. So at the trial, it's very clear. It's either you meet your burden and your guardianship is granted, or you don't meet your burden and your guardianship is denied. Or you could have a partial guardianship that's granted, meaning take away some rights, give the guardian some rights, and other rights remain with the ward. All right, so when I took the bench in 2016, the law had really just changed at the end of 2015, and it was kind of catching on, kind of not. But the Texas legislature decided, you know what, guardianship is not always the answer. What can we do to give people the tools in the law to try and take care of their loved ones themselves? And they don't need to be rushing to the courthouse. So there was a huge change in the law in 2015. And I think now, at least in Tarrant County, and I've heard around the state, people are really starting to look at the changes in the law and trying to adapt. And many are very happy just to hear that they can go about taking care of their loved ones and they don't have to rush to the courthouse. The courthouse is always here. It's not as open as it should be right now, in my opinion, but we are still here. All right, so how did the law change? First of all, there's clear and convincing evidence. And I will say, usually what we're familiar with is beyond a reasonable doubt. So if you are facing a criminal conviction for a crime, the state has to prove their burden beyond a reasonable doubt. Then you might have seen some courtroom dramas, and they talk about the scales of justice and its preponderance of the evidence. And if I tip the scales of justice just 51% to my side, I win my case. Well, clear and convincing is in between a preponderance of the evidence and beyond a reasonable doubt. If you want to put it in percentage, maybe it's 75%. I've never actually seen it legally put in percentage. It is a term that is a firm conviction or belief. So the burden to put someone under guardianship is to create in the trier of fact a firm conviction or belief. Typically, your judge is your trier of fact, but you are entitled to a jury trial for guardianship. So first you have to prove by clear and convincing evidence that the person is incapacitated. And that's defined as unable to provide food, clothing, and shelter for him or herself, care for their own physical health, manage their own financial affairs, or need a guardian to receive government funds. You do not need a guardianship to receive government funds. In fact, typically the federal government doesn't really care about what I say or what I do because I'm a state court. So if somebody tells you you need a guardianship to get the SSI money, tell them you do not and ask to be the representative payee. You also have to prove by clear and convincing evidence that alternatives to guardianship that would avoid, alternatives that would avoid the need for guardianship have been considered and are determined not to be feasible. Same with supports and services, that they have been considered and they have determined not to be feasible. So a lot of times you're going to have a doctor's letter that says, oh yes, they're totally incapacitated. Well, I've seen people that are totally incapacitated according to the doctor, talking just like I'm talking, and I look at the doctor's letter and I think, oh, wait a second, this person can't do anything according to the doctor? I'm having a conversation, and but for the court that I serve in, I would not know that this person has capacity whatsoever, whether it's because of dementia or an intellectual disability or stroke. So, but a lot of times you'll get that from the doctor. So you've got to see, okay, wait a second. Are there other things where we can show the judge that maybe this person isn't as incapacitated? Maybe they've got some capacity to do some things, or maybe they're not incapacitated at all. Now, alternatives and supports and services we're going to talk a lot about. All right, but I am actually going to turn it over to Elizabeth Hart now. If y'all can unmute Elizabeth. And I'm going to allow her to talk, hopefully this works, about alternatives and supports and services, because she is just so much better at this being a social worker than I am as a judge and an attorney. Elizabeth?
I'm going to go ahead and change the spotlight over to Elizabeth, but Judge Brooke, I think you still need to control the slideshow since it's showing from yours.
I am going to do my best. Thank you.
Right.
I'm going to take a quick screen grab in case we have to go on to the next topic. Hi, I'm Elizabeth Hart, and I am meeting y'all this evening from my home. So if there's some outside noise, it's because I live downtown. So excuse that, please. So as Judge talked about, the changes in the law in 2015 were pretty significant. And one of the big emphasis that the legislature was asking judges and attorneys and any court staff working in this area of the law was to seriously consider alternatives to guardianship. And so I'm going to go through several of those alternatives. You'll see them there on the screen that Judge is sharing, alternatives being the medical power of attorney. The person has the capacity to sign the medical power of attorney, the durable power of attorney, the durable financial power of attorney, declaration of mental health treatment. Those are documents, those are legal documents that a person does need to have a pretty significant capacity to sign those documents. So you want to sign those documents before you may have any advanced Alzheimer's or dementia. The representative payee, as Judge mentioned, that is a federal program through the Social Security Administration that can be handled and managed directly with the Social Security Administration and does not have to involve the court or you coming in to get a guardianship. Sometimes our folks just need a little help with money management and a joint bank account, being able to review their the spending or their purchases, or having a TrueLink card, which is, you know, a card that's endorsed by Social Security. And so that's why I'm going to use that that term, that business model, so that that person that is working has access to their money, but it's a controlled access, so that they are not exploited or taken advantage of by someone that they may have met on the bus, or someone at their job site, or even staff. Management trust, special needs trust, those are things that are going to require an attorney. A special needs trust, any of you parents out there that are raising or have raised a adult child with special needs, you may look at your estate and say that you want to leave your adult child with special needs part of your estate. That is a way to do that. Through the special needs trust, Medicaid does not count those assets. And then those monies that you bequeath to them through that special needs trust can be used to enhance their life. Art therapy, music therapy, maybe taking a special vacation with an adult sibling that doesn't have the means to take that burden, that financial burden on by themselves. Another important document, the Designation of Guardian. Anyone over 18 that has the capacity to sign that document, it's very important to do that. And the listing on that document initially says, who would you like to serve as your guardian in the event of future need that you lose capacity? And Judge, first off, as the assistant court investigators, we are looking for those documents, especially on the cases where the person is aged and there's an application filed for a guardian. So the person has got either traumatic brain injury, or they've developed some dementia or Alzheimer's. We're looking for that designation of guardian document, which is part of your estate planning documents. And in that document, you may list the first 3 or 4 people that you would like to serve, you would like to have serve as your guardian. But I like to tell people that the most important part of that document is the last thing listed, which says, gives you an opportunity to list the person you absolutely do not want to serve as your guardian of your person or as the guardian of your estate. And judge will be bound by that. Whereas judge is not bound by those first suggestions of who you want to serve, because people that serve as a guardian need to go through a background check. They have to be willing to serve, and they have to be a good fit for that person under guardianship. So alternative forms of decision-making based on person-centered planning. And I will be preaching to the choir, I'm sure, if I try to tell y'all how person-centered planning works, because as Cindy has, I've heard Cindy say many, many times, nothing about us without us. And so that's kind of the crux of person-centered planning, making sure that decisions are made that are going to impact that person, then that person has input. And then the Health and Safety Code, Chapter 313, is also an alternative to guardianship, because the decision tree, the legislature has written out a decision tree in that legislative chapter that talks about if there is no guardian, and if a person arrives and has no ability to communicate or is incapacitated and they arrive at a medical facility, then that Chapter 313 will identify folks that can make decisions for that person. And of course, in the event of an emergency, a doctor is going to do everything that they need to do medically to save that person's life. Judge, would you like me to continue on with some other supports, or we've got another slide coming up?
Well, I can't control it. I can't. No. Alex, you may have to make me whatever. While you're doing that, I'm just going to reiterate the Health and Safety Code.
Yes.
Since if any of us were in that car wreck I mentioned earlier and they had to cut off our leg to get us out, and then of course we're going to be in shock, and so we're not going to be able to talk about what we consent to and what we don't consent to. So in my case, my spouse would have that opportunity. If they couldn't get a hold of my spouse, then my adult child, I don't have an adult child, so then it would go to my parents. So that's for everyone. If your child is in the hospital and they're over 18, and if they're in the hospital, Chapter 313 is going to apply. It's the regular doctor's visits that become more difficult. Mm-hmm. Let me stop share and go back and share again, because it still didn't let me. More alternatives. These are mostly if there's money involved, which means you're going to have an attorney, so we're not going to spend time on those. All right, supports and services.
Okay, so the other big change in 2015, which was reiterated with even stronger legislation in 2017, is this big topic of supports and services. And so I'm just going to read this very quickly. The supports and services are available. Formal and informal resources and assistance that enable an individual to meet that individual's needs for food, clothing, or shelter, care for the individual's physical or mental health, manage the individual's financial affairs, or make personal decisions regarding residence, voting, operating a motor vehicle, and marriage. So as a social worker, I look at this statute and I think, wow, this is a social work statute, yay, because supports and services is what we all use every single day to get up and go about our things done. We use a alarm clock on our phone to wake up. We use our phone to communicate to someone, whether we need a ride or what our daily schedule is, or we call into work, or when we're leaving work. So those are supports and services. Other services may be more formal, like when you are engaged in Medicaid waiver programs, case management services, again, that person-centered planning. And the supports and services around you are supporting you such that you are getting food, clothing, shelter. You've got someone, you're a representative payee for your loved one that has a disability, so you're managing the money. Or you've got the other services. You've signed up, you've got the QMB, or you've got an assistant that comes in, you've got a pill minder. There are so many parts of supports and services, and the legislature really brought these to the forefront, saying, look, let's stop removing people's rights just because they have a disability. They shouldn't be penalized because of that. We need to just look around and look at the environment and say, what is available? How are they utilizing the supports and services to make their life as full and engaging as possible? So as a social worker, we look at that with each one of those applications and the suggestion or the information letter that Judge had mentioned earlier. We look and say, are there supports and services meeting this person's need? Do we really have to go forward and remove civil rights? One more there. Oh,
supported decision-making agreement.
Yeah, so then there's that supported decision-making agreement. And that's the adult with a disability voluntarily enter into a supported decision-making agreement with a supporter. So that supporter is the person that's going to help explain in simpler terms, in terms that the person with a disability will understand it, so that that person with the disability can really lead their life, be in charge. And the person that's supporting them can give them the positive aspects or the negative aspects of the decisions that they're having to face. What are the consequences? That document should be recognized in medical treatment, at the bank, and with schools, and will help, and that supporter can help communicate that decision along with that person with a disability.
And for parents and even kids who have parents that maybe are getting dementia or something, this is a great tool. But also, just when you go to the doctor, don't be so quick for the doctor to say, oh, you can't be in here, this and that. Well, Abby, do you want me to be in here? Or Abby, you want me to be in here? Isn't that right? All right. They're called leading questions by attorneys. And when Abby says yes, then you have a right to stay there. All right. When you say, Abby has a supported decision-making agreement and I'm her supporter and I'm allowed to be here. I will tell you, this was kind of unheard of when I took the bench in 2016, but a lot of people have heard of them now. A lot of people are using them. And you may want to try this out, see if it works for your loved one before you try guardianship. There's an attorney who will bring guardianship cases, but what she does first is she brings everybody into the room and she decides, okay, can this person sign a power of attorney? Can this person sign a supported decision-making agreement? Let's look through all these different things, and she will draft these documents. And if those documents don't work, then she will put the money that you paid her towards drafting those documents towards a guardianship. And I think that's a wonderful thing because she's done several things in that. One, she's tried to allow your loved one to live their life independently and with you supporting them, but don't we all have supports, right? I still talk to my parents about decisions, important decisions. Of course, I talk to my spouse too. And then the second thing she's done, if these don't work, she's given herself evidence to put in front of the court to show that supports and services and alternatives are not working. Okay, I think Elizabeth is still with us for questions at the end.
Yes, I will be here.
Okay, that was kind of the end of supports and services and alternatives. There was a couple questions I saw while she was talking. Yes, this law applies to all of Texas. Somebody said, well, then why do courts do it differently? So I'm a statutory probate court, and you saw that I have 12 people. The citizens and the commissioners of Tarrant County have made this a priority, and so they have funded the people that we need to investigate these and to oversee these. And so we're very lucky. Not all courts have that. Also, I'm a statutory probate court, so I don't hear everything under the sun. And when you get into some of these smaller counties, their courts hear everything under the sun. So they need to be educated. When you come to court, don't assume the judge knows every law about everything. I do not pretend to know the law on everything. I still look up the statutes. If you bring me something, in fact, usually during guardianship trials, I'm looking at the statutes just to make sure there's not something there that I didn't miss. And the laws change. We're in legislative session right now. They're looking at changing different laws. And so they change every 2 years, really. So educate your judge if you're in a smaller county. I can't imagine any judge would not like the fact that you cite him or her the statute that you're trying to prove, whether it be guardianship or something else. And somebody asked if they can request a social worker. I don't know of any courts in Texas that have social workers on staff, except for my court. Probate Court 1 in Tarrant County has someone, I think she's part-time, but we actually traded back before me, they traded other positions because social workers were so important to my predecessor, and we use them a little bit differently, but I agree they're very important. So guardians of the person, powers and duties, like I mentioned, they're delegated from the state of Texas to my court or the court wherever you're in, and those duties are delegated to the guardian. You cannot move someone from a less restrictive to a more restrictive placement until after you provide notice to the court, and we're going to be asking about that. So if your person is living at home by them or on their own, or even with you, and then you're going to put them in an assisted living facility or a group home where it's going to be more restrictive, we're going to be asking about that. And yeah, more restrictive isn't defined. So you always want to give notice to the court if you're going to move your loved one and they're under guardianship. Sometimes you have to give certain people notices. So it used to be they had to opt out. Now they have to opt in if they want to get notices. That was another question I saw about divorced parents. So in certain instances, parents can be joint guardians, but in other instances, they're going to have to be one's the guardian and one will have a possession order. These are some of the hardest, and I see this in divorced parents, and I also see this with siblings of a parent that's under guardianship or they want to put under guardianship, where one parent or one sibling says, well, you know, Susie wants to stay at home. We have supports and services. They're delivering her groceries. They've got the pill helper that Ms. Hart mentioned. And so they've got the means to stay at home, or I want the child to stay at home with me. And that's great. Then the other sibling or the other spouse says, no, Susie needs to go to the group home because she'll learn to live on her own without us around all the time. She'll have friends and that kind of thing. Or the sibling says, I want mom to go to the memory care because it'll expand her life and she'll live longer and they can take better care of her. Okay. These are differences of opinion. One is not better or worse necessarily. And so that is a really tough decision that you're putting on a judge that doesn't know you and that does not know your loved one. And I will tell you, with my hearings, you're going to get several hours if you need them. Most judges are going to give you, like I said, before me, they used to be, 10 or 15-minute hearings. So I encourage you to try and work those things out, because I'm going to listen to you, even if it's, several hours here, but then I make that decision instead of you guys making that decision because you couldn't for whatever reason. And it's not going to be based because one's better than the other. A lot of times it's just kind of what the proposed ward has told me, because they're going to have a lot of input. I'm really going to listen to them and what they want. And sometimes mom wants to live in her home, even if it's not, she was not going to get to live as long. She wants to enjoy her home. and not go to memory care or something like that. Or, you know, Susie wants to live with mom and stepdad instead of going to the group home. And so those are really, really tough cases. All right. This is guardian of the estate again. You got to act like a prudent person would, and you're investing in everything else. And you're going to have an attorney. So we're not going to spend time on this. Ward's Bill of Rights. So this was actually came in through the silver-haired legislature. So they requested the Ward's Bill of Rights and got that pushed through the legislature that basically says, hey, we need people who are under guardianship to do the most that they can do. So if I see, and I have seen, oh, the ward sits in front of the TV and the ward's basically bossing the guardian around and the ward doesn't do anything except for watch TV and eat. No, because remember, you've asked the government to come into your home. The government is here. It's hard for me to call myself the government, but I am, and I am not going to allow someone to sit in front of the TV all day and eat. They're going to, if they can get a job, they should get a job. They might need to go to, you know, day hab, or you're going to have to get them out and take them to the park. We're going to do something besides somebody just, you know, essentially doing nothing all day. And then you've got to tell, as a guardian, you've got to tell the ward that they do have all these rights. They have the right to ask for their rights back every year. They have a right to have the court investigate whether they should get one or all of their rights back. And that comes back to a question I saw about, okay, well, can I just get a guardianship and then later on, if we don't need it, we'll just stop. It is very hard to get someone off guardianship. It is even harder to restore all their rights and get them off guardianship. I've had a lot of people say, well, just get guardianship when they turn 18, and especially with intellectual disabilities, a lot of times by the time they're 22 or they're 25, they've really learned a lot of life skills. They don't need a guardianship anymore. But in order to restore, the statute in Texas says that essentially the disability is gone, or the, I believe it's called the medical issue, or I'll have to look up the exact wording, is gone. Well, dementia does not go away. Autism does not go away. Down syndrome does not go away. That doesn't mean those people can't learn to live a full life and make decisions themselves. It may just take a little bit longer. Well, dementia, you're kind of going the other way. You probably had capacity, and then it's going the other way as far as not having that. But, you know, I pray for the day when we're doing a ton of restorations because there's a cure for dementia and these types of things, but it's not there. And so a strict reading of the statute, it is extremely hard to restore. What we can do is we can modify. So we can modify and give some rights back, and then we can close for supports and services and alternatives. That leaves someone out there without all their rights back, which is troubling. Now, in reality versus the legal world, I know you're out there without your rights, but nobody at Best Buy is going to say, oh, I'm sorry, Amy, you used to be under guardianship. Can I see your restoration letters? Not going to happen. So in reality, you may be fine. But if you're thinking, oh, let's get it now and then we'll get them off, I caution you, it is very hard. And some courts won't even hear restoration hearings or closings and that kind of thing. They just, you know, we've had problems where I think Miss Hart was told by a doctor, I'm not going to be a part of this. And the woman was the president of like the HOA at her nursing home. She just, I don't know, she had a bad spell kind of, and somehow was under guardianship. It was before my time. And we had to go out and find a doctor who would give her an honest evaluation just to tell us, honestly, does Ms. Hart need to pursue this for either a restoration or a modification and closing? And so it's very, very hard to do that. All right, temporary guardianship. So let's say that something happens, okay, to your loved ones. Oh my gosh, you know, we thought about getting guardianship and we didn't get it, and now we're just stuck in this mess. Okay, well, we have temporary guardianships, all right? So you only have to show substantial evidence, not clear and convincing. And it's substantial evidence they may be incapacitated, not they are incapacitated. That is a big difference in the law. And interestingly, that's something I picked up when during a hearing, as I said, I read statutes. I was like, wait, that says may. That says may be incapacitated. And one of our court attorneys was like, you're right, I never noticed that. So it's a lot easier to get a temporary guardianship. And again, that's temporary. We haven't fully taken away those rights. And then there must be an imminent need. So, you know, health and safety code's not working for some reason, or someone has, you know, they're in a position where they're neglecting them or they're taking their money or something like that. It does expire typically in 60 days unless there's a challenge, but really a challenge is just the attorney ad litem filing an answer can be a challenge if we need a temporary guardianship longer. These have worked really well in my court to get someone to a place where they don't need a guardianship. So we can do things within a temporary guardianship that become alternatives and supports and services to a permanent guardianship. So that's kind of interesting how we've been able to use those in my court to actually avoid taking away somebody's rights permanently. All right, so my question to all of you is whether you have an estate plan. Do you have a will? Do you have a power of attorney? Do you have a durable power of attorney, which is who's going to handle your money? Do you have a designation of guardianship, should you need one? Do you have what's called a living will, or what you want the doctor to do should something arise? You know, if you have full capacity, you need to make sure that these documents are in place, because you don't want me making decisions for you because I don't know you. I know Cindy probably the best of anyone, and I can tell you she doesn't want me making decisions for her. She wants her husband to do that or her daughter to do that, not the government, not a judge who is going to have to hear this in an hour or two and make a decision on your life. So please make sure those are in place for yourself, and then you can also get them drafted for your loved ones if they have the capacity to do so. All right, this is hopefully a video that's going to play. I think that you are going to recognize some people, and I think it just really solidifies that this isn't a rush to the courthouse. You can always bring a guardianship, okay? Your person can be 25, they can be 92. And if that's when it becomes where you can't give them the health care and the education or whatever it is they need, you can always come to court at that time.
You might turn on the captions if it has them on this version.
Judge, we can't hear.
Y'all can't hear?
We cannot.
Yeah, no, there's some sound problems. Go ahead and pause it. We can have Cindy play it quickly from, because I know you've got the link to it somewhere. I know I'm putting pressure on you, but I know you've probably got the fastest link to that video.
Okay. I'm trying to, okay, Alex, walk me through minimizing my screen, because I've got a full screen and I can't. Thank you. There it is.
Yeah, that was, she just turned off the screen share. So go ahead and find it, and then go ahead and share your screen when you get there, okay?
Yes, ma'am.
They're
my assistants, but I'm like the techie nerdy one.
I was just trying to think if I could share it outside the PowerPoint, if that would work.
Yes, that should work, and that's what I was going to try to have her do. So if you already have the link to it pulled up.
I do.
Okay, go ahead and do that.
Let me share a different screen.
Perfect.
Okay.
Yeah. So this should have better sound then if it's shared straight from your computer and not through the PowerPoint.
Okay. Is that good?
Yes. You may need to turn it up because you can hear there's background music to it. Ooh.
I don't think it's working.
I think it might just be a bad version. Yeah, there's still very muffled sound. Go ahead and pause it and we'll see if Cindy's version works.
Well, why don't we do this? If we're good, we'll end the recording and then y'all can add that to the recording on YouTube. And that way I can start answering questions while we are, while Cindy is looking for the video to play here. Does that work?
Cindy, you can unmute yourself. Does that sound good to you?
Yes, and then I don't know how to screen share.
Okay, so just hang on to that then. Just send me the link in the chat and I'll set that up. And we'll do that in a minute. But let's go ahead and Gary, can you stop recording and we'll go ahead and take some questions.
All right.
I know
Thank y'all.